Hello, and welcome to the McMurray & Schuster Biometric Privacy Laws webinar, Keeping an Eye on Compliance. This is the latest installment of our weekly Thirsty for Knowledge Thursdays that we started several months ago. And we thank you and appreciate you being here with us this afternoon. Today, I'll be presenting with my colleague, Chris Wager. Chris is a senior attorney with McMurray & Schuster. He's with our firm's compliance and litigation teams. And in this comprehensive role, he helps clients nationwide understand and comply with state and federal telemarketing and privacy laws. He provides defense against government enforcement actions and also litigation and consumer protection matters. He brings more than a decade of experience working with businesses of all sizes across highly regulated industries, including automotive, financial services, healthcare, energy, and retail. He has extensive experience with the TCPA, or the Telephone Consumer Protection Act, and other telemarketing laws, and has helped businesses develop proactive compliance programs, as well as successfully defend them in litigation and class action lawsuits. I'm Michelle Schuster, and I'm a founding partner with McMurray & Schuster. I've been working in the consumer protection and defense industry for over 2 decades now. I'm a prior consumer protection chief from the Ohio Attorney General's office, and I'm currently general counsel for PACE, the Professional Association for Customer Engagement, which is the only nonprofit trade association exclusively dedicated to representing contact centers. So with that, a quick disclaimer. This presentation and the materials we provide is for informational purposes only. We always recommend that you consult with an attorney for your specific legal needs and with any legal questions that you have. So some of you might remember the 2002 sci-fi classic that was set in 2054 called Minority Report. It did an incredible job of identifying the technology of the future and especially when it comes to advertising. There's an iconic scene where Tom Cruise's character, John Anderson, strolls through a mall where ads scroll his eyeballs to identify him and to call out ads to him. Have a beer, take a trip. How did you get those? How did you like those Gap tank tops, John? Well, that was a movie, but it was very realistic as far as things exist today, well before 2054. Things are starting to look increasingly Minority Report-ish. Major ad startups have become more sophisticated at identifying who consumers are, and not only being able to access persons across the web, but also in person. I'm sure you have found it commonplace that you have personalized ads that retarget you or remarket you. For instance, you're looking for shoes online to purchase, and you notice as you go to the next web page, ads will follow you to attempt to sell you shoes. We know more about consumers now than we ever have. Next slide. For instance, IBM and Japanese marketer NEC have developed very extensive databases of photos and systems that have AI facial recognition. And these are just a few of the firms that have become very sophisticated in this area. Next slide. So you might wonder, why should I be concerned about this? Well, as we know, the future is now, and you only have to look at the company Clearview AI. Clearview AI became a victim of data breach after a hacker gained unauthorized access to the company's entire list. It exposed for the first time the details of the organizations that work with Clearview. Clearview is an AI company that makes use of a vast database of over 3 billion images that have been scraped from social media platforms like Facebook, Twitter, YouTube, Venmo, and LinkedIn. And they currently use these images to match against photos of suspects and provide those to police departments. We also know that from that data breach that the list of clients that Clearview AI uses includes the big 4 box stores, ICE, law enforcement agencies around the world, And we do know also that we are hearing an awful lot from consumer advocates and civil libertarians in the wake of this breach. They call this basically a nightmarish situation, believing that governments and advertising companies and retailers shouldn't be running our faces against as they would call it, a shaddily assembled database of billions of our photos in secret with no safeguards against abuse. Next slide. So you're probably asking yourself, beyond a really interesting movie like Minority Report, why should I care about biometrics? Also, what are biometrics? And finally, what should I do with regard to biometrics and the use of biometrics? So with that, Chris, let's hear why we should care about biometrics.
Okay, thank you so much, Michelle. We're here today, like Michelle said, to talk about biometrics, which are becoming a much more commonplace area in our society and with businesses. And we first want to start talking about why it's important, why you should care, and why this topic should be on your radar. The first and most direct implication is there are a number of state biometric regulations that are now in place, really leading the way. Many of you may be familiar with this. There's a statute in Illinois referred to as BIPA, the Biometric Information Protection Act, that sets up specific safeguards regarding the collection, use, and potential sharing of biometric information. In addition, the California Consumer Protection Act has specific provisions regarding disclosures related to biometric information. In addition to those states, a number of other states, we have 6 or 7 states listed there that have either recently within the past year or two enacted laws or currently have legislation that pending that will regulate biometric information. In addition to specific biometrics laws, the general Unfair Deceptive Practices Act standards, both under Section 5 of the FTC and state law analogs, can affect the collection and use of biometric information. And we have seen in the past precedent where the FTC is particularly interested and takes enforcement actions against kind of new and novel technologies that may not align with current consumer expectations with respect to the data collection that is occurring. You know, here consumers may not be aware, to use Michelle's example earlier, the Clearview AI cataloging billions of their photos and running it in facial recognition. That's not something that's commonplace that consumers are expecting. So therefore, that would be an area where we believe the FTC may believe that more affirmative disclosures and discussion of those data practices would be more necessary than is otherwise the case. Now, looking specifically at biometric, this is kind of the big scary guy in the room, and that's because the Illinois biometric law contains a private right of action that the way it's structured is really amenable to class litigation, and kind of the trifecta to make matters worse is there's a $1,000 to $5,000 statutory violation for each and every violation that occurs. So that could be each fingerprint scan can open a company up to $1,000 to $5,000 of liability, and that's, you know, each scan for each person that happens. So those numbers can add up very quickly. Within the last month, the big thing in the news is Facebook. They just entered into a $550 million class settlement in federal litigation out of California related to the Illinois law. And that dealt with, I'm sure you all are familiar with Facebook, you know, where in the past you could have the suggestions for tagging on photos. That was the subject of that because Facebook was using facial recognition technology, which is biometrics, to suggest tags. In addition, a couple other examples, you know, that aren't as big as Facebook with billions of users. There's a company called Zayo, which provides data storage locations. They were using fingerprint scans for access, security access to their locations. This was a class of 2,200 people, so it looks like, you know, they're settling for about $450 a person in that settlement. Kimpton Hotels was another defendant that recently settled. Kimpton had 5 hotels in the Chicago area, and they were using fingerprint scans for their employees to clock in and out of work. There were 1,000 employees there, so that settlement was about $500 per person. The trend here, it's even getting worse. We've noticed in kind of our observation in the cases that we're looking at is that cases are actually now settling in the $800 to $900 range per person. So this is a number that's really high. I would say the trends here are even higher than settlements that we see in the TCPA area. And the laws are very similar in that they really are kind of the combination of strict liability type standard along with these very high statutory damages.
And there's kind of some breaking news here, Chris, around this issue. Just this week, the Seventh Circuit surprised many folks, I think, in this area by keeping a BIPA suit in federal court. The defendants had argued that the federal court didn't have standing to hear this specific type of state law, and mostly it was around the lack of economic harm. But as a result of this case, I think we're sure to see many more of these cases being filed and being maintained in federal court. Do you think that's the trend we'll see in the future?
I do, and that is kind of it's a blessing and a curse. I actually, we've represented in litigation some class defense of these cases before, where we attempted to remove to federal court Illinois because it's a much friendlier venue than state court typically can be. In the past, we've actually had cases remanded because courts found that there was no injury in fact and no standing, and we were stuck back in state court. So in a way, if this can open the door to a more friendly venue, this actually may be a little bit of a positive development, but unfortunately, you're still stuck with a strict liability statute with high statutory damages. So even a friendly venue won't get you that far.
That's right.
And then, and the other issue is, the increased attention and scrutiny that's coming to biometrics these days. And in addition to this specific, biometric laws that are being enacted, as we mentioned, there are 7 states. This trend is only going to continue to increase. And even outside of the pure biometric space, the New York data breach law was specifically amended last year in order to include biometric information as one piece of sensitive information that is subject to the data breach notification laws. An interesting another interesting aside that shows that this is only going to continue to grow. There have been a number of articles and reports in the news lately about potentially using facial recognition, other biometrics in order to do contact tracing with COVID-19, as we're talking about moving on to the next phase in responding to that. So there may be a lot of interesting questions raised, kind of weighing the public health benefits along with these statutory regulations and looking at the potential contact tracing. So now that kind of hopefully we piqued your interest and showed you why it's important to be cognizant of this issue, we kind of want to step back and talk about what exactly is biometric information, because I think there can be some confusion on the subject. I like to think about it by breaking it down into biometric into its 2 parts. First, you have the bio part, which deals with, it really has to be some sort of something that's reduced down to your biology or your appearance. That can be a retina or iris scan, fingerprint, voice print, or kind of a handprint, or which is kind of similar to a fingerprint. Now, the metric part is what's interesting, and that's what can cause confusion, is that imaging or that aspect of you needs to be used for identification purposes. So, a simple voice recording, sometimes people are concerned, if I'm recording somebody, am I recording biometric information? Well, not unless you use that recording in order to use it for identification purposes. Same thing with pictures. If there's just a picture of someone, that is not biometric information until there's actual face recognition technology that's scanned on that image. So it's important that's the second necessary step, is that the information has to be used to identify someone. And lastly, the kind of an interesting thing to point out too, and a lot of these statutory schemes, when they talk about biometric information, the information aspect of it really applies to anything that is derived from that biometric information. one statute, I kind of pulled some language from BIPA here, the Illinois law, that defines information as any information regardless of how it's captured, converted, stored, or shared. So therefore, the facial recognition can be pulled from publicly available photographs of you. It does not have to be an actual scan of you personally. It can be derived from a recording or a picture or some other means. Also, what's important about that, it makes sense stepping back why these biometric laws are enacted. It's because your biometric essence is something about you that cannot be changed. And if that's compromised, then there really could be harm that could be inflicted on you, once your information is reduced down and used for illicit purposes. However, even if the information is converted, hashed or somehow derived in a way that's no longer that can no longer be used to reverse engineer and hurt you, that doesn't matter. That comes up in a lot of instances where we've dealt with clients. They're doing fingerprint scans, but the technology used reduces the fingerprint scan, to an algorithm, to a code that can't be used for any other purpose other than within that system to verify your identity. However, Illinois law says, that doesn't matter, that there is no actual threat of harm associated with this. The fact is, this is information that is somehow derived from biometric information. So kind of with that big picture in place, we just kind of wanted to go through some examples of biometric information. And these examples are either coming up through the litigation that we've seen or in dealing kind of personally with our clients. The first and not the biggest, but a big area is fingerprints. The main thrust of litigation in the biometric space are employers who are using fingerprint scans for timekeeping purposes. This is a great system where it allows employees, it's super quick. You don't have to worry about using a punch card or typing in a long code. You're able to do that. So it's really to the benefit of everybody. And it's also beneficial for companies because it prevents buddy punching, where somebody's clocking in and out for a friend to get them some extra time. And it's great just because it provides data security. And like we saw with that Zayo thing, there's some areas where you need secured access, and a fingerprint is a great way for security purposes. In addition, we see fingerprints being increasingly used with consumers. One big Illinois case dealt with a theme park where you had your annual pass, and instead of having to worry about carrying a card or some other identification around, they just obtained your fingerprints. You could walk up to the gate, put your finger on it, and you're able to go to the park all year. Well, that subjected the theme park and the theme park company to a large and expansive class action litigation. In addition, I'm sure at the airport you see those kind of smart carts or lockers or other technologies. Those companies have also been using fingerprint technology, for you to set and lock your locker or return your cart. Very convenient thing, but having implications under these biometric laws. In addition, we're seeing a lot of action in the voice recognition area. I'm sure everybody, deals with Alexa, Google Assistant. Forgot to put Siri on here, but that may be the biggest one of the bunch. And it's important. This does get into the area of biometrics as opposed to just recording, because it's really interesting. Even the one example is Google Assistant uses voice match technology, where they can actually distinguish between who is saying "Hey Google" and personalize results based upon it's you, your spouse, or your child who's summoning Google in that instance. In addition, we see a lot of identity verification. This is happening in the call center space a lot, or any businesses that's done over the phone, where doing voice print can be a great way to confirm somebody's identity. In addition, and kind of a little far more outreach there is, companies can use voice recognition for consumer insights or consumer tracking. In the past, I did some, we've done some work with with a fast food restaurant. That this is kind of an interesting story where they they were using voice print technology in the drive-through space, where you came in, it would remember who you were and what you ordered before. So instead of in the future, instead of hearing do you want fries with that, you may hear you like that burger with pickles but no onions, right? So it's just interesting, and there's so many different applications where this voice recognition technology can go. In addition, we're seeing face recognition. As I mentioned before, Facebook was subject to that $550 million settlement based on that friend suggestion tagging. In addition, Shutterfly, I'm sure you're familiar with, where you can upload your photos, they also had tag suggestions and were subject to numerous class action lawsuits. In addition, retailers, and this goes back to Michelle's point at the beginning, using Clearview AI and other companies, where they're using retail metrics, kind of enhanced customer counting, where they've got different camera technologies in their stores, and those technologies are using facial recognition. Kind of the most publicly facing acknowledgement of that is they're using technology to confirm the age and gender of the different individuals who are walking in the stores, but we're getting more and more inclinations that these are actually be using to track the identity of these shoppers, either to a specific person or in order to match shopping behavior between visits or between visits to different retailers. With that in mind, the next question is what you should do. One of the most important things to do and to comply with these specific laws is to create a written biometrics policy. This is important not only to comply with the laws, but also as a best practice so that you have standards in place in terms of how you're going to collect, use, and store this information. A written policy really needs to include a retention schedule that is honored and given thought. And these retention schedules really should include a provision and an acknowledgement of when the company no longer needs to keep that biometric information, and to assure that the information is deleted when it's no longer needed. At the end of the day, holding this information does open a business up to risk, and to the extent that risk can be minimized by just not holding on to this information in perpetuity, it definitely should be taken advantage of. In addition, there needs to be data security standards, including encryption and other industry standard applications that that treat this information as truly sensitive. This policy needs to be accessible, and by accessible I mean made available. If it's a consumer-facing check, then this should be published in a way that your consumers can see what this policy is. If you're using biometrics with employees, it should be important that these policies are included with the employee policies and procedures that are also otherwise made available to your employees. In addition, it's very important to describe the biometric practices in your business's privacy policy. This ties also back into the CCPA, which specifically requires point of collection disclosures and other notifications to consumers, and specifically calls that out for biometric information as well as other personally identifiable information under the Act. And with the privacy policy, it's not only, it's important in two respects as well. First is, it needs to be able to match the expectation of the customers, and that so customers understand what you're collecting and for what reasons. In addition, it's really important to make sure that the policies that you're discussing are accurate. It's not enough just to disclose it. If you're using the information in a way that's inconsistent with your policy, that can really open you up to actions. We've seen a number of FTC enforcement actions against companies who, while their data collection practices weren't violative of any laws, the problem was that they were being inconsistent, their practices, with what they were disclosing in their policy. So again, please ensure that you follow the general rule that your privacy policies are consistent with your actual practices. In addition, it is important under these laws and also as a best practice to provide anyone with written disclosures at the time that you're initially collecting biometric information. That disclosure needs to include a statement of what particular biometric information is collected. It can seem redundant here. If someone's putting their finger up to a fingerprint scanner, it's readily apparent to them exactly what biometric information it is that they are providing. However, we've seen through a number of court cases that doesn't matter. Even when it is apparent, courts state that you still need to follow the stringent standard of in writing notifying that person of what biometric information is being collected. In addition, a business needs to disclose what the purpose of that collection is, what the biometric information is being used for. In addition, as we discussed before, having a retention schedule and retention policies, that information also needs to be provided at the initial point of collection disclosure. These all need to occur prior to that information being collected, and in addition, it's good to have or it's not good, it's required under a number of laws to have written authorization from the consumer for that collection. So, typically you can have a written disclosure that's provided to them, and then at the bottom there can be the language where the consumer then can sign, through an actual signature or other e-sign acceptable ways to acknowledge that they received the disclosure and to acknowledge that they consent to the collection of the information. In addition, just kind of ongoing concerns that are important here. As I mentioned before, make sure that you are keeping an active eye for data security standards. As we just discussed before, the New York Shield, which is their data breach notification law, was amended to cover biometrics. We presume that in addition to specific biometric laws, that breach notification laws will increasingly treat biometrics as sensitive information. And as time goes on, in addition to initially having that retention schedule, consider, your business model as that changes, the need to keep retaining this information and in what form. And at the very end, you have to be vigilant about the sharing of this biometric information, including the sale of it. If you're using vendors, ensure that those vendors are using adequate data security standards. And also be aware, a number of these state laws have outright prohibitions on the sale of biometric information. And as we know from the CCPA and other laws, the definition of sale can be quite broad. So to the extent that you're considering sharing this information with any third party, please be extra vigilant and keep an eye towards any applicable laws.
Yeah, so, as we talk about the future is now and bringing this presentation full circle, it's interesting to note that the companies that are working in the fields of biometrics and are selling or using biometric information, you'll notice a common theme that in the absence of federal legislation or federal laws and regulations in this area, or comprehensive state laws and regulations, companies are trying to get out in front of this issue and hopefully develop the policy before it is developed by the regulators, who may not have as much of an insight or information into biometrics and how to best regulate it. And so IBM is a good example of that. You can find their policy lab precision regulation and facial recognition paper on their website. And specifically in this position or idea paper, IBM tries to make it very clear that there are different types of biometrics and that all biometrics should not be treated the same, just as Chris went through what the biometrics are in this presentation. And they specifically point to the fact that if we're relying on facial recognition, we need to understand the difference between face detection, which basically is just a system that would detect that something is a face, versus facial authentication, which would actually identify a specific person with that face and those facial features or that facial image, versus facial matching, which would take a face or some type of biometric facial scan and compare that to a database to identify specifically who the individual is that they've just taken that facial scan from. And importantly, what IBM and other companies that are similarly involved in this industry all point to is the importance of the types of things also that Chris has talked about in the what we should do. And it is that notice and consent are so very important. So if you are using biometrics in your operations, even if not required by a specific state law that your company is within, or the area in which you're collecting this information, that you should still probably think about the notice and consent obligations. IBM certainly advocates that. And for instance, if you are gathering information on a social media platform, that you insist that there be some type of disclosure of the type of information that is disclosed, and even potentially consent that that information be disclosed. If you're collecting this type of information in a retail establishment, you might want to consider signs that would provide notice that information is being collected, or surveillance equipment is being used, or video camera are being used, those types of things. And there seems to be a particular amount of attention now that is being applied to information being shared with other countries, especially if it's of the type of information that can specifically identify individuals. So if you are sharing information internationally, that's something that you might want to give some extra thought and attention to, even in the absence of regulations around that. So with that, Chris, I think we can wrap up here. And you know, just as that previous slide, the thought being that, you know, the threat is big, but the compliance steps are small at this point. And we really hope that in watching this webinar and listening to Chris discuss the various regulations that are popping up out there, that you'll become aware of the fact that biometrics are something that are starting to be regulated, and there are specific penalties associated with that. And class actions that are beginning to form, and that you'll know to ask the right questions so that your company does not run afoul of these regulations. So from Chris and I both, we appreciate you being on the webinar today. We do have a few questions that we're going to stay on the line for, and you are welcome to do that as well. And those of you that have other appointments, we appreciate you being here today, and have a great day. So Chris, I know that a question came on that, and let me pull this up real quick. Is it better not to have a biometric policy, publishing a bad biometric policy? This is where you get to have your opinion portion of the webinar, Chris.
Yes. Well, can I say neither? Is that an acceptable answer?
Spoken like a true lawyer.
I would say, I mean, there really isn't the outlines and what's required for a written policy are pretty basic. So, you know, there shouldn't be a reason to have a bad policy. It should take minimal work in order to create a policy that covers what's required by these various statutes, and that is thoughtful and makes sense. So hopefully this isn't being too squirrely, but I think my answer is that a good policy should be pretty painless and easy to do.
Yeah, I agree. So, Chris, where do you see this going in the future? Do you think we're going to have more state-specific laws and regulations? Do you think we'll see anything on the federal level? I know that you know, one of the regulations that we don't often think about in this area has to do with voice recording, and the laws that prohibit voice recording without notice that voice recording is happening, and that's a lot. And that telemarketing and contact centers, that's something that those folks are very aware of, giving consent to record or monitor types of notices. But you know, where do you see this going in the future?
Really what I see is I think that it's going to be more a hodgepodge state by state basis. We haven't seen any indication that the federal government is looking to take this on, and I really do think that other states are going to take Illinois, the lead from Illinois, and begin to act and enact these statutes with private rights of action and stiff penalties. It's interesting, the Illinois law is kind of an interesting aside that we did get into, has been on the books for a long time, I believe well over 10 years, but it wasn't until about a year and a half ago that these lawsuits started popping up, where this was a law that was out there that the plaintiffs bar didn't realize, and then they did and started taking advantage of this. But I think that this kind of onslaught of there's hundreds of class actions now and coming out of this Illinois law. I think that's kind of awoken us, the sleeping bear, and I think other consumer advocates in other states are pushing for similar laws. So I anticipate that other laws will quickly be enacting similar laws.
Yeah, I think that's right. I think that's right. All right, well, we have no other questions. Again, thank you for joining us today, and have a wonderful day. Bye.